if he can't make it.
Great. I guess we can start with the housekeeping.
Sure. I can do that. Welcome committee members, liaisons, and members of the public to the Eligibility and Budget Review Committee meeting. Thank you for joining us. We're using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. To use the raised hand feature by phone, dial *9 on your phone's dial pad to raise your hand, and do the same to lower your hand. Please utilize this tool to virtually indicate that you'd like to speak in order to help the chair facilitate the discussion. Please note that all Legal Services Trust Fund Commission and committee meetings will be recorded and posted to the State Bar website. And as a friendly reminder, this is a video conference, so please be aware of your surroundings behind you.
Great. Thank you, Erica. Should we do a roll call?
Yes. Connolly?
Present.
Mccloskey? Fightmaster?
Here.
Bennett?
He's connecting.
Connecting audio. Okay. Blakemore?
Here.
Klein? Meeker?
Here.
Okay, and then I'll go through liaisons and State Bar staff. Selena Copeland? Bonnie Huff? Juan Wing?
Here.
Shannon?
Yeah, I'm gonna have to just dial in from my phone. This is too much noise. I'm sorry.
Okay. Shannon Crossley?
Here.
Elizabeth Hom? Brady Dewar? And Dan Passmanic?
Present.
Great. Thank you all for joining. And I think this is our first Bagley Keene reinstituted one. So I think everyone's in different locations this time. I'm in a little conference room myself. So at this time, I think we'll call for public comments. And what I'll say is if the people who want to make public comment can keep themselves to about 3 minutes, that would be great. And you know, obviously the committee, if there's public comment from speakers on agenda items that we're addressing later, we may ask if you're available to stay on for any questions. So have anyone who would like to make public comment?
Yeah, Charles Evans has his hands raised. I'll allow him to talk.
Great. Hi, Charles, or Mr. Evans, you're Asian Americans Advancing Justice?
That's correct.
Okay, great. Yeah, go ahead and make your public comment.
Thank you. I'm the supervising attorney over at Asian Americans Advancing Justice Los Angeles. My project does a lot of voting rights and redistricting work, and I wanted to comment on item 5C, specifically with regard to how redistricting related voting rights activities are considered by the committee. We understand the difficulty in quantifying the impact of redistricting advocacy on indigent persons and their communities. Redistricting is a process that affects the entire state, entire counties, entire cities, and special districts. At first glance, that might seem too broad for consideration. After all, voting access and redistricting impacts how all communities are represented at all levels of government. But that view disguises the stakes that this kind of line drawing has for indigent communities. The determination of district lines impacts directly the attention that our most poorly served communities receive from their representatives, as well as how local and state resource programs are put into effect. Programs like Medi-Cal, Section 8, CalFresh, et cetera, are all affected by how these communities are kept together or not. When districts are drawn fairly and communities are kept intact so they can speak with a single voice to and through their elected officials, these programs and policies that repair deteriorating local infrastructure and provide vital economic support to indigent communities are likely to be implemented. The problem is in ensuring that these communities are kept intact. When these communities are fractured among multiple districts, they no longer speak with that one voice. In a given district, there may be too few of them to influence local elections, and so their needs are ignored. Sidewalks go unrepaired, programs to support indigent families go underfunded or undeveloped, and language access needs are dismissed because the population within the district is too small to trigger statutory requirements. And when community members are indigent, they lack the money that can make up for the lack of numbers. These communities must be kept whole for their voices to have meaningful influence over the representatives and laws that govern them, but who advocates for keeping these communities intact when community members are poor or low income? They don't have the same sort of commercial interests or financial interests that might organize and keep areas together. They lack the kinds of community resources that might facilitate organizing. And oftentimes we're talking about communities that are made up of immigrants or first-generation Americans who have cultural and language barriers that impair their ability to understand, let alone participate in the redistricting process, or communities where residents are working multiple jobs just to make ends meet. When you're talking about people who are often indigent, in a world where spending money is a form of speech, their voices are the ones that are most difficult to hear. Redistricting might have a broad impact on a variety of communities, but the stakes are so much higher for these indigent immigrant communities. And yet those are the ones that are most in danger of being ignored. It's for those communities that organizations like mine do this kind of advocacy to elevate their voices. The committee has previously found other activities to be acceptable despite the difficulties in quantifying the impact for indigent persons. Having fairly drawn districts greatly affects the maintenance of neighborhoods and the allocation of resources needed by these indigent communities that we serve. And we urge you to please be mindful of those facts when making your determination. Thank you.
Thank you, Mr. Evans. Are you available to stay through the meeting to this agenda item in case anyone on the committee has questions?
I will do my best, but unfortunately I have another conflicting matter that I have to attend to. I have to be off by 11:30.
Okay. Thank you. Are there any other people who'd like to make public comment?
No
No.
one else has their hand raised.
Okay, that's fine. We can move along. Okay, great. Why don't we move now to agenda item 3, the approval of the meeting summary and action items from the March 4th, 2022 meeting. First off, does anyone have any comments or concerns about the minutes? Yes.
I'm not sure I was here, although it shows me here. I think, I don't know if Dwan or anybody remembers me at the last minute not being able to come, because it doesn't look real familiar when I read over the minutes. And I had a lot of stuff going on right then, and I think I suddenly couldn't come.
Oh, you think we missed, okay, look, we can check that, right, Erica? Maybe the recording.
Yes, I can double check.
Okay, thank you.
So should we wait on approving until we know whether?
Do we need, yeah, if you don't need the vote, doesn't really matter, but I thought I'd point it out.
You can just vote next time, and
Sure.
do two and one.
Yeah, or maybe we can circle back to this if someone is able to confirm while we're in the meeting. If not, no big deal. We'll just do it next time. Thanks, Louise. Any other comments before Pamela?
Okay, I'm sorry. Did we actually adjourn at 10:42? Was it that? I was.
Can you say that again? I'm sorry, you broke up a little bit.
Okay, I may have to delete my turn my chat off. My question was, the time adjournment was it 10:40?
It was a fairly brief meeting. Yeah.
Okay. All right. Thank you.
I think last time was primarily kind of updates, right?
Yes.
Okay. Also, I thought we started early, but maybe I'm wrong on that.
I think we might have started at 9:30 or
Okay.
I'm not sure, but I do remember it was just primarily updates, sort of setting the stage for subsequent meetings this year. So
Okay.
It's amazing. Any other comments or? Okay, so why don't we wait on this until we figure out Louise's attendance, and then we can circle back either the end of this meeting or next time. So thank you for addressing that, Louise. Okay, let's move then to number 4, the staff reports. And it looks like the first one's on the Chapman University.
yes. So at the last meeting, I had reported that Chapman University anticipates closing its operations, but we weren't sure if they were going to accept any funding for 2022 at that point. We've since learned that they've declined to sign their grant agreement, so they won't be taking any funds for 2022. We had informed them that if they did accept any funding, even if they weren't going to use it for the whole year, that they would need to go through a monitoring visit. And so they decided to just not accept their grant award because they were only operating through April of this year. So their total grant award of IOLTA and EAF combined was about $50,000 for 2022, and that funding will be redistributed in the next grant cycle.
Got it. So it gets put in the pool for not this year, but for next year.
Yeah, correct. Yeah.
Any questions? Jim, you have your hand raised?
Yeah, can you tell me why they're closing the program? I mean, it's a clinic program, right?
It is a clinic. I don't have a specific reason. They just notified us sort of their timeline and their intent to close, but we haven't, I don't believe we've been given a specific explanation as to sort of the reason for that.
I spoke to them. It's a funding issue. The university is just cutting funding, and so they
So they're eliminating their clinic programs, is that it?
Well, that one, I don't know if they're eliminating all their clinic program, but they've discontinued their funding for that particular clinic. And we did say to them, like, because they always clearly qualified, they've been a grantee. If they start up again, then to reapply for our funding.
Okay, well, I'm on that subcommittee that's looking at law school clinic programs. I was just wondering if it was a particular auditing rule or funding source rule or supervisory rule that they ran afoul against that they have problems with.
No, they didn't have problems. It's just the university decided and it gave them very short notice
Okay.
to wind down.
Selena, you have your hand raised?
Yeah, just a quick question. When the funds are put back into the pot, are they earmarked for that county or are they going back into the corpus of everything?
No, it's for that county.
Right, thank you.
Yeah. So we do, we run the formula based on whatever the distribution amount that the commission decides for next year. And then we run the formula just on that small amount. This is going to go through codification because when it's nominal like this, what you'll hear about this, maybe a better is just to go generally. Only that's nominal, we have to decide what that is because sometimes we get unreturned funds and it's really hard to track back at every county. But in this instance, because we don't have a standing rule, it will go back to the county.
Have they already closed up shop?
My understanding was that they were not accepting new clients after April, but then they will completely shut down by July. So.
Got it. Okay.
And then, sorry, just the last thing I wanted to say about that organization is that we have received all of their reporting requirements from 2021 as far as their expense reports and their evaluations. So they should be all set for us to close out their grant.
Great. So we don't have to chase them for anything. That's awesome. Yeah. Great. Any other questions or comments from committee members? Okay, why don't we move then to the next one, responses from organizations with the significant findings.
Sure. So also at the last meeting, I had talked about two organizations that had monitoring visits in 2021 with significant either program and or fiscal findings. We had not yet received their responses to our monitoring memos at that point. So earlier this month, we received responses from Social Justice Collaborative as well as Yuba Sutter Legal Center for Seniors. And Social Justice Collaborative's findings were related to use of a board finance committee, having appropriate staff supervision, and improving communication with the state bar. In their response letter, they indicated that they had created a finance committee, which had been the concern, and given an update on sort of their timeline for the rest of the year with that committee's activities. They have hired additional staff attorneys since the monitoring visit and laid out a plan for providing adequate supervision for, support or non-attorney staff. They've also hired a grants manager who's going to be the main contact with the state bar to improve our line of communication. And so based on their response to the monitoring report, staff was satisfied with their responses and is going to schedule sort of a short check-in later this year just to confirm sort of the progress on those responses, but most of staff's concerns were resolved with their reply. As far as Yuba Sutter, they had several findings related to their board oversight, a lack of a treasurer, which was a repeat finding for their board, the State Bar's inability to access their general ledger during the fiscal portion of the monitoring visit, missing cash receipts, concerns about their calculation of qualified expenditures, and then uncleared transactions on their reconciliation reports, which was also a repeat finding. We received a response from them about the actions the board is taking. They're identifying and vetting some treasurer candidates. They're trying to improve their oversight in terms of, excuse me, they're working on finding a new directing attorney for the organization. And they responded with their plans for how to address the fiscal findings, but given sort of the extent of the findings in that report, staff is planning on scheduling sort of a smaller or mini monitoring visit later in the year to follow up with them, which will be like a little more intensive than the follow-up for Social Justice Collaborative. So we will likely ask one of the committee members to attend with us as part of that monitoring visit.
Any questions or comments from the committee? Selena.
I'm happy to wait my turn after committee members.
Okay, that's fair. Does any of the committee members have? I'm not seeing them raise hands. Otherwise, I would. Why don't go ahead, Selena? We value your input.
Well, I talked with Susan about this because I think she referenced in her response that she reached out to LAC, but we had not yet talked, and we've since talked. And I think the program just needed some like tools, and so I shared a lot of tools with them. I think that Susan is very serious about correcting these, and I would agree that a follow-up visit would be appropriate because there hopefully will be a new directing attorney by year end, and so it can kind of set that person off on the right foot with understanding how the State Bar staff is supportive, and you want them to get the right tools so that they have those fiscal controls. So I would agree that a follow-up visit seems really appropriate for this program.
Great. Are these newer programs?
Social Justice Collaborative is a new program. This is its first year of funding. Yuba Sutter is not new, but I don't know off the top of my head how long it's been a grantee.
Obviously long enough to have like a repeat monitoring.
Yeah, correct.
Go ahead, Selena.
I think that the tricky thing with them, they've been around for a long time, but they're a very small program. And I think they're older, the past bookkeeper retired.
Yes.
And so I think that's just the challenge of everything that existed in that person's head of writing everything down at the same time that they're transitioning their leader. But I think that the first monitoring visit was really good for the current leader to make sure that everything that she's doing is written down as well.
Good. Thanks. Catherine?
Just 2 comments. I agree with the approach. I'm a little concerned that some of the findings are the same as 3 years ago, which I think just adds to why it's important to do that. And if you need a volunteer, I'm happy to join the visit.
Thank you.
Do you, in looking at their financials, just a quick question, do we have any concerns about the money, like how they're spending money, or is it just a controls issue, or is there something else going on, do we think?
I think they were able to articulate their approach, for example, to qualified expenditures, but there's no written policy for it, things like that. So just trying, I don't think there was any concern about malfeasance, just, possibly serious omissions. So
I mean, it was concerning, I will say, like they didn't track like their cash receipts, including the checks from the bar. I mean, that just seems like a red flag to me, which is why like, I really think it's important to go back and make sure, like, it's one thing to say, fine, we're in this transition, but it seems like a program that hasn't had written procedures for a long time and isn't really doing like just basic fiscal management that I think, I mean, I really appreciate the bar staff raising the issues, and hopefully the messages they need to get their house in order pretty quickly because I mean, they're basic things, honestly, like
Yeah.
not keeping track of what cash you're getting in, like that's a problem.
Are they, and I apologize if this isn't the memo and I just don't forget it, but are they at the size where they have to do an audit or are they just doing a financial review?
I think they're small enough to do a financial review, but I need to double check that.
Okay.
Yeah.
It just seems like these are the kinds of things that usually an audit would kind of put some, there's some requirement of some discipline in that level. And understandably, we keep it lower to, you know, because it's expensive to do an audit, but yeah, sorry, Dan, you have your hand raised. Do you have a comment on that?
Yeah, I want to say that there are some programs that get OAA funding, and I believe that Yuba Sutter at one time was one of them, that have to do an audit for AAA, even though we don't require it. So I don't know if they're still receiving that funding, but just because they don't have that much money coming in, if AAA makes them get an audit, then they might have one anyway.
Okay. Yeah, the only reason I'm kind of surprised is if they're doing an audit and they're not tracking their like cash receipts, like I'm a little curious about what their auditor is saying. And maybe one thing we might want to check in about is if they are getting an audit, like how independent is their auditor, maybe? Obviously, independence of an auditor is, you know, a public filing thing for SEC registered companies, but obviously it's also best practices. So I don't know, maybe that's not an issue, but I'm just surprised as well, to Catherine's point. Any other, we don't want to bankrupt them on the, you know, on getting an audit, but like, you know, we have due diligence, so. All right, any other comments or questions? Okay, it sounds like, you know, Erica, I guess whoever decides to do the follow-up visit, sounds like Catherine's up for volunteering. If anyone else is interested, you can let staff know. Dawn?
Yeah, I mean, we do share the concerns of the seriousness. So maybe Erica, this is something we could schedule like in the next like 5 or 6 months versus like at the end of the year.
Sure.
Yeah. Thank you guys. And thanks for the reporting. You don't need anything vote-wise from us, right?
No, thank you.
All right. Okay, there's no more comments. We can get into kind of some of the meat of our stuff as well. So let's turn to number 5, business. And 5A is review and approve audit extension requests. And so I will turn this over to Erica. I'm going to talk about this.
Yes, thank you. Since I didn't post a memo, I thought I would just make a quick slide that we can all look at. So 2023 IOLTA EAF applications were released at the beginning of April. They're due back May 16th. As part of that process, organizations need to submit their audits, or if they are eligible, a financial review. Usually audits are due on May 1st. This year they're due May 2nd because May 1st is a Sunday. And then our schedule of charges and deadlines allows staff discretion to grant an extension through the application deadline of May 16th if an organization submits a request. Anything beyond May 16th this year would require commission approval for an extension on their audit. And the wording in the schedule of charges and deadlines is that it needs to be upon a showing of extraordinary circumstances. So far this year, I ran a report this morning. We've had at least 18 requests for an extension through the application deadline. And then of those, at least 7 organizations anticipate that they will not be able to meet the May 16th staff discretionary extension deadline. I've also heard from 2 to 3 prospective applicants that they're not sure if they would be able to meet that deadline either. Based on the 7 that don't think they'll meet May 16th, their estimates are anywhere from May 18th through June 30th. June 30th is the furthest out that we've heard so far. Last year, the committee gave sort of an anticipatory extension to these organizations through May 31st. But I believe the nature of the discussion at that point last year was that we were still, kind of in the middle of the pandemic and that extraordinary circumstances just existed generally. So we wanted to alert the committee to the fact that there are these pending requests to see if you want to give extensions now or wait until later in the application cycle to see if organizations are unable to meet that deadline. Yeah, so that's pretty much it.
Thanks, Erica.
Mhm.
Catherine, you have your hand raised?
I just had a question. Is this a good time to ask or sorry?
Yeah.
Yeah, the other person in this room set up. So are the 18 current the current requests for extensions from the same programs as last year, different programs? Do we have a sense of who's requesting an extension? Because I think one of the topics was sort of the people who on an ongoing basis request extensions versus, something happened and it's a one-time thing.
I don't know the exact number that overlaps with last year, but I can say anecdotally that I have recognized a number of the organizations are the same. I would say probably at least half, but I can't say the exact number at this point.
And I guess my second question from the staff perspective, is it helpful if we take any action now for, I don't know, like a short extension, or is it more helpful if we just review them all at once? Does staff have a preference as to how the committee should proceed? Like if we March through May 31st, does that help or not help? I don't know.
Yeah. Some of the organizations, it would help them, and staff would be able to just review the application as having been complete at the time the audit submitted. But there are, I would say, at least 3 or 4 that don't think they would even be able to make May 31st. And so then we will need to address this again, I think, at a subsequent meeting.
Pamela? We can't hear you. No.
Sorry, Mayor, unmute.
No problem.
I thought we agreed to give an extension, I think, to the end of May. And I know for the the pandemic, we were asked to be very flexible. That was used a lot, and so that was done for that period of time. And I'm thinking that they should be pretty prepared to get back into gear, so to speak, and to be timely in their presentation of their materials. That way, State Bar staff is not having to delay any calculations that they need to make. So, were there any circumstances that were beyond the pandemic as a reason for not being prepared to submit on time?
Yeah. For this application cycle,
Mm-hmm.
we've had a few where they switched auditors, and because they engaged a new auditor, they weren't sort of already on their schedule, and the auditor indicated that they couldn't fit them in before a certain date. In many cases, they will have the draft audit available for staff review, but won't have it finalized by the application date. So, that's most often what we're hearing, is that either the auditor won't finalize by May 16th, or that the board won't be able to take a vote before May 16th. And then in some instances that it is related to the pandemic and not having open offices or being able to access information.
All right, pause.
I'm gonna close it. I'm sorry.
No, it's okay.
From my tablet. Yeah. Because my other question is, being that this is an ongoing deadline every year, how prepared are they? Are they being intentionally prepared to be on time? Or are they just relying on staff being generous to say you can submit it at the end of May when it's really due May 1 or May 2?
Mhm. I mean, I think they are endeavoring to meet the deadline, but
Okay.
you know, after explaining their circumstances, for example, to their auditor, if the auditor says they can't fit them in, then,
Mhm.
you know, I don't know if they have much option at that point.
Okay, thank you.
Selena, do you have a comment?
Yes, and sorry, I have some auditory challenges. If folks aren't speaking, do you mind muting yourself? Thank you. Went away. Maybe not. My question is this is just the audits, right? It's nothing else. Like the rest of the application is complete. Is there anyone who hasn't completed the application, you know, and also it was an audit, or is this otherwise complete except for the audit?
I mean, we have indicated that so the deadline hasn't passed yet. So the assumption is that the rest of the application will be complete, even if they can't meet the audit deadline. We do remind organizations that they need to submit the application regardless by the deadline. And then, you know, there may be consideration of their audit extension request after that, but that they still need to meet all the other requirements by May 16th.
I mean, that's really my main concern here, because I keep hearing horror stories of organizations who said their auditor dropped them and they're scrambling, and they reach out to LAC and ask what auditors are still taking clients. We're scrambling here. But I would worry a bit more if, you know, to go to Louise and Pamela's comments or concerns that organizations aren't respecting deadlines. If they're otherwise getting everything else completed, the audit still seems to be a challenge, but organizations sometimes aren't the ones with power, and so they're trying to get the audit in on time. So I just wanted to name that concern, that I definitely think that organizations want to get everything in on time, and it would only worry me if they were exhibiting a pattern of not doing things on time, or not having a reason, or just saying we couldn't get it together.
Dawn?
Yeah, I just want to share. I think it's been particularly hard for programs and organizations around the pandemic. I mean, there's just delays. I'm not sure if it's like taking longer because they're doing it right, but I know for even our auditing, we were like engaging like 2 years out and negotiating that. It's particularly difficult, that from what I've seen.
Apologies, I'm getting notifications. Okay, if I can make a point, this extraordinary circumstances standard is something that's by rule, right? Like we don't have discretion to not find extraordinary circumstances in order to grant an extension. That's correct, right?
Yes.
Yeah, and so I guess in the past 2 years, we've sort of found that the circumstances involving the pandemic constituted a blanket extraordinary circumstances. And so I guess the question is, what do we have in front of us that suffices for extraordinary circumstances at a blanket level? And that I'm not saying we don't, I'm just saying that to me, seems like what the standard we need to meet. So I'll just throw that out there. Louise?
I think, you know, most of you know that I tend to be on the liberal side of letting these organizations get their paperwork in, and you track them and you know who are the, you know, the people who tend to have problems and don't. But this time it seems like you're saying that these 18 or what 25, however many, if those are added together, I'm not sure, are repeat offenders, so to speak. You know, they're people who have over in the last several, you know, couple of years at least, have again not had the auditor or whatever the problem was. That concerns me, that there are organizations that, you know, sort of repeat this year after year. And that's, you know, for me to say that, I think is probably somewhat pertinent, because I tend to be more lenient than some of the other people on the board, on the commission.
Yeah, I mean, to that point, you know, the high number maybe suggests that there is something going on in the environment anyway. Do we have, and this is hard because I know they haven't sort of maybe made formal requests, but are these like individualized issues, like each of them are having an issue, or is this something like, you know, broad, more, you know, broader that is applying to this environment?
It seems to be individualized, but that being said, a number of them did cite issues with their auditor, not necessarily the same auditor, but just difficulty scheduling. So, I mean, I think a few of the organizations have submitted, you know, formal like letters for consideration. Others have been having interactions with staff about this. If the committee would be more comfortable, we can get, you know, letters from each organization that anticipates needing something beyond the application deadline. That way you can hear directly from them, either in writing or at the meeting.
Catherine?
I think what I'm hearing is a suggestion that we look at them individually with a staff recommendation. Sorry, there's now 2 of us in the same room, so I think it's gonna cause problems. You might have to mute while I'm talking.
Yeah, I think everyone else should mute.
Yeah, I think it's just, anyway, so I guess that's my thinking. You have to go.
I can't find my name in this.
No.
It says I'm muted. It says you are muted.
Okay, great. I think it's just the background when I talk, it's coming out of your speaker, but I'm not sure how to fix it. Anyway, I guess my thought is, given the standard of extraordinary circumstances, that's an individual determination, and it feels like we should probably just decide them individually unless staff thinks there's a group that are going to be there at a date that wouldn't fall within, you know, needing an extraordinary circumstance, and then I'm happy to consider what that date would be.
I think that this was more, you know, motivated by efficiency, but staff doesn't have a problem with waiting until kind of that deadline has actually passed and submitting, you know, individual requests from the organization. I will say that there is some level of anxiety, obviously, among organizations, not knowing, you know, that they're going to submit their application and not knowing if the audit will be accepted, even though they are making efforts to get it in. So, but as far as, you know, our process or our ability to review applications, that won't necessarily be impeded by waiting until the next meeting.
So I guess one piece of flexibility I could see would be like if they submit a draft audit by that date, that seems fine to accept that, knowing that then we're just waiting for approval and not to have to bring those to the committee. That just seems like a kind of easy place to land, because, you know, they have an audit, you know, the audit's completed their work and now it's just being reviewed by the organization essentially, right? So maybe that's a place to get to be flexible, for example.
I also wonder whether there's a way to like delegate to a couple of committee members in the interim so that we can try to be efficient and not not make them anxious. Like I don't want to like leave them on tenterhooks. I'm just concerned because in the past we've done a blanket because the world was in the middle of a pandemic and it was, I think, justified for us to find extraordinary circumstances. And right now, at least, it could be that there's like a trend of auditors dropping, you know, nonprofits for various reasons, but we don't have that. We don't have like evidence or even anecdotal necessarily. I know that Dawn has said like it's an issue, but I'd like to have something, and maybe we can delegate so that we can have that efficiency that staff wants, but we also are complying with like the rule, you know. And also I think there's this element of like, if there aren't extraordinary circumstances, but we still want to grant, I know Catherine and I were on a working committee to try to carve a space to like allow conditions. Maybe that's a way that we can sort of start working under some of that auspice. Like maybe there's room, and Brady may have a comment on that about, you know, if we don't find extraordinary circumstances, but we don't want to like keep people from getting funding, is there a way we can grant with the conditions, and the conditions are have a plan or whatever. So I just want us to not ignore our rules, you know? So that's just my comments on it. Pam?
I would say pre-pandemic, there seems to be always a handful that are not timely. So so even pre-pandemic, that's has been an issue for the board to consider.
Well, I'm getting a sense, and I don't know if this is accurate, that the committee is not comfortable giving a blanket approval of an extension to everybody at this time. Do we want to just wait for the company, the groups? I mean, if I'm wrong on that, please let me know, but we could either wait or we could delegate some authority. Catherine, you have your hand raised.
Yeah, I just thought your suggestion of delegating authority, identify a couple of people who can more quickly look at them. I'm personally fine accepting a draft. Maybe the state bar staff already does that as just an indication that the audit has been submitted, so we don't have to spend time looking at that. I suppose assuming they're going to get the full audit, the approved audit submitted in some reasonable time thereafter. So I think both of those together are good ideas. So
yeah, I know in the past we've done, I think, and Erica and Dawn, correct me if I'm wrong, where we've sort of accepted a draft audit and then let them sort of run the tables on that basis, with the understanding that if their final audit differed, we would not, like, to their benefit, we would not sort of give them more. But Dawn.
Yeah, I think that was the practice before that rule change. So Brady, is this consistent if we took the draft audit with the extraordinary? Can we do that under that state bar rule?
I don't recall this happening before, but I mean, I guess what they're really doing is they're giving us something on time, right? Or with a certain extension, and then we accept corrections, and we actually demand corrections of things that are inaccurate. So I think that's sort of the way to rationalize it under our rules. I mean, even if the grants are going on, they find out something was wrong in their finances, they're obligated to tell us, and we can adjust downward their grant accordingly.
Yeah, I mean, do you think we could do like an approval with condition? I'm just not sure if we can do like a full approval with like, if they don't have a draft and we don't have extraordinary circumstances, we can't just straight approve, right?
Yeah, no.
Yeah.
I mean, I think what we're really taking is we're taking, hey, this is your submission, and we understand you might be updating that, and we'll address that.
Yeah, but does the rule require a final audit? Do we know?
The rule, we require a final audit. I mean, if we're gonna issue a check, we need a final audit. But at what point is, and I'm hearing Brady say that's fine to get the draft until we get the final. We ultimately need a final audit. Yes.
I think Erica's question was like the rule, right? This says audits are required. Is the word audit defined? I think is kind of what Erica was saying.
Yeah, that's sort of what I'm even looking at now.
I'm just wondering if this, like, well, we can take the draft, without extraordinary circumstances, except the final later, if that's okay, if that's an appropriate workaround under the terms of the rule, is all.
We went over some things that were going to come up. This wasn't.
Sorry, Brady.
No, of course. That's
that
what I'm
rule
here
is kept
for.
in the schedule. It's a state bar rule, but it's in the deadlines.
Yeah. Yeah.
And I'm sorry to be like kind of a nitpicker on this. I want us to not ignore our rules. And that's why we hopefully.
I actually think that's right. And now what we're trying to do is just be practical about how to implement it, right? And so that's that both make sense to me. And so.
Yeah.
And did the work that we did on the rule that allowed, the conditions, wasn't that for any deadline? So I think that rule could apply to this.
Well, the problem was that for any other rule, there was no extraordinary circumstances requirement, but for the audits, there already is. And so we kind of kept the extraordinary circumstances standard in place for full approval with no conditions. But we said if there were not extraordinary circumstances, the committee could still approve, but with conditions. Meaning you had to talk to, and what the conditions were within the committee's discretion. So it could be, have a plan for next year, meet with us later. It didn't have to be onerous, but the idea was try to get them on the ball on the timing thing. And I, to your point, think there's room in the rule now to allow that, but I defer to Brady on that interpretation.
And it's also, even if you approved it for extraordinary circumstances, I think you can say, like, we approved it because the extraordinary circumstances was you changed an auditor and they couldn't fit you in. But going forward, we expect it to be on time and we need a plan to sort of make sure that that's going to happen. You can't just have, I am sympathetic to things happen and there's extraordinary circumstances. I am far less sympathetic to there's an extraordinary circumstance every year.
Right.
And that's why I asked the question at the beginning, like at some point, extraordinary circumstances just become the ordinary way you seem to be doing business. So I guess that's to me kind of the reason for even in extraordinary circumstances and have a plan, because it can't be extraordinary every year.
I think actually the way to harmonize this, what we're doing with the rule, and I think it makes sense, is to say that really it's about the extraordinary circumstances and what we're saying that justifies. Because, so correct me if I'm wrong, we're not allowing anybody to not submit their, we're not contemplating allowing anybody to not submit an audited financial statement before allocations are on. Is that correct? So I think what we're saying is, hey, your extraordinary circumstances justify, meeting the deadline in this way, which is you've got to give us a draft, and under no circumstances can you not give us a final by X date. So it's sort of, as Catherine's saying, extraordinary circumstances is a concept that lets us look at, okay, what problems are you facing, and what can you do or what can't you do based on that? Does that make sense? So really what we're saying is the extraordinary circumstances justify you giving us the draft and making sure that it's final by X date.
Right.
And again, that's not going to be an extraordinary circumstance next year.
Right. So I think what might be appropriate, because we've only had one instance of extraordinary circumstance, and that was involved an executive director who had some issues. And so I think it might be appropriate to kind of delegate to a couple of people who can review the individual details from each of the organizations, and then, with some thoughts about whether changing the auditor, getting an auditor, dropping them, we obviously want to be, it's just in the absence of knowing what each of these 7 or 18 circumstances are, it's hard for us to know whether they're each extraordinary. But in order to ensure that that the organizations are not unduly stressing, I think it would be good to get a couple of people who'd be willing, and maybe we can delegate authority to them to make these judgments in a timely way. Does that make sense to the committee? Any concerns about that? Okay. Do we have, Brady, go ahead.
May I just quickly ask, how is it that that we're having this discussion on the commission? Was this delegated by the commission? This is going to ultimately be our recommendation. All right, this will ultimately be our recommendation to the commission.
Yeah, it goes to the commission.
Gotcha.
Yeah.
In June, I guess, maybe is when the commission's meeting, right? So.
Yeah. So it seems like we would have a couple people go review everything, come to us with, either make decisions in advance and then inform us and then make recommendations to the commission. But it would be, rather than waiting for us in June to do it all together. Sorry, Brady, go ahead.
Oh, sorry, that was, I meant to take my hand down.
Oh, okay. So yes, to your point, I don't think that whatever working group could actually grant the extension, but they can sort of vet everything and put together the recommendation that would go to the commission.
Yep.
Does that seem to make sense to everybody? So we get okay. Do we have any volunteers? And then can we put together a motion?
I'll volunteer.
Okay. I'm also happy to volunteer, but if anyone else wants to do it, I'm happy to not volunteer. Okay. I think Catherine and we're like the deadline queens right now with our working group, so maybe it'll be us. Great. Should we do, we put together a motion? Some language on that.
So I'll move that a small committee of Catherine Blakemore and Erica Connolly vet the request for extensions and make a recommendation to the full commission for its June meeting.
Does that make sense? Does that work for you guys on staff? Erica, is that amenable?
Yes, I don't, Brady, if it's not a staff created working group, are we gonna need to notice their meeting?
So how many people are?
It's two. Can we make it a staff so then we don't notice the meeting?
Vaguely keen.
But I mean, they're just they're just giving advice. It's not really a delegation.
Yeah, it's not.
Okay.
Yeah. So two should be fine.
Great.
And staff, whatever works easiest for you, like, I think my schedule is flexible. If you guys want to do this earlier than later to get, it going, that we don't want to make this hard for you. We just want to stick to the rules too.
Sounds good.
Great. Okay, so Catherine's motion, does anyone second?
A second.
Okay.
Connolly,
Yes.
McClogy, Fight Master,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
Klein,
Yes.
Meeker.
Yes.
The motion passes.
Thank you, staff, for putting up with our annual deadline, semi-annual deadline discussion. Okay, and then we have the next one is review and approve the 2022 budget revision request.
Yes, we can actually skip this item. We had a couple organizations indicate they may need to submit a budget revision, but they haven't come in yet. So we, if we receive those and they require a committee review, we'll put them on the next agenda.
Awesome. Okay, thanks. Great. All right. C, review and approve impact litigation and advocacy work.
Yes. So we, staff prepared a memo and attachments that were in your meeting materials regarding ILAW, and our senior program analyst, Dan Pasmanic, will kind of kick off the presentation on the issues on this item.
Good morning. I'm going to share my screen and see if I can walk you through a little PowerPoint about ILAW review this year. Can everybody see what I can see? 2021 impact litigation. Excellent. Let's see. Here's what we're going to talk about today. First, why we're even talking about this. Then what are our authorities and definitions and standards for review? There are a handful of ILAW activities that we want to identify for your awareness that staff has tentatively approved, but we want to clarify that and get your confirmation. Then there's a handful of reports that have actually been elevated for review that Eric is going to walk you through. Very briefly, why are we doing ILAW review at all? Stakeholders need this information. Well, ILAW reports are impact litigation and advocacy work reports. They're the reports that explain what the numbers mean on our case summary reports. If there's just a one, but there's 10,000 people who got helped, it's good to know that because the one just doesn't tell us that off the chart. So this is the information that brings the numbers to life for us. And it's critical to know what kinds of services are being provided and where and in what amount, so that we can design funding programs. We can make sure that other stakeholders are ready for the issues that are coming their way, and that we can coordinate with them to address them most effectively. We also have a very practical reason for looking at ILAW reports, which is that it's a way for us to identify activities and expenditures that should be deducted during the application process. If an organization is engaged in work that's not qualified, this is an easy way to find it and for them to let us know that in the application they're about to submit, they'll let us know how much that cost them and they'll take it off. I want to pause briefly here, just ask if there's any questions so far, but feel free to raise hands. And Erica, I don't have a whole screen here, so if you could let me know if there's a question. I don't want to ignore anybody. But let's briefly talk about our standards for review here. What I've done is tried to minimize the amount of text on the screen, but there's an awful lot of rules that we follow to do the ILAW review. For QLSPs, the issues are understanding the primary purpose and function, which is providing civil legal services without charge to indigent people in California. Allocation calculations are governed by section 6216 of the IOLTA statute, and that says that allocations are calculated based only on the expenditures for qualified legal services within individual counties. Indigency is one of our primary criteria for deciding whether or not an activity is qualified, and there's a definition for it at section 6213D, and it's got lots of different ways of determining indigency. But we have to make sure that one of them applies. And finally, the definition of legal services is found in State Bar Rules. Rule 3.672A says that legal services are the professional services of a member of the State Bar, and similar or complementary services by paralegal or a law student under that licensee's supervision and control. When we look at the individual reports that come through, we have slightly different criteria for litigation reports versus advocacy activities. For litigation, we'll look to where the action took place, whether the client was indigent, and there's some special factors to consider when it's an organizational client or a class action. We consider the group most likely to benefit, the relationship of the issues raised to the concerns of indigent people, and whether there's a disproportionate impact on indigent persons. As for advocacy activities, we actually don't have any authorities that officially say that advocacy is a legal service, but we've always considered it one since the beginning of the IOLTA program, really, although we've only been tracking ILAW for about 7 or 8 years. But advocacy activities do require legal expertise. They are something that you need to be a lawyer to do well in many cases. And when lawyers are involved in drafting a bill, in legislative campaigns, enforcing a law or regulation, where the majority impacted were indigent, that's an advocacy activity that we have typically found qualified. Again, I want to pause here because that's a lot of data. And if there's specific questions about where we're going, I'm happy to respond to them. But we've got a slightly simpler approach now for support centers. Support centers are different than QLSPs because their clients are the QLSPs. It's not, the community members at large. So their primary purpose and function is to provide legal training, legal technical assistance, and advocacy support to people who provide legal services for the indigent. This is also broken out in their in Rule 3.672B, where they give a lot of details about whether you can help pro bonos or people who aren't coming to you through a QLSP. And the short answer is a support center cannot provide direct representation as a qualified activity unless there's a QLSP involved, or the QLSP asked them to assist, or if they're helping a pro bono attorney who's providing services without charge to an indigent person. So their rule isn't about helping the indigent, it's about helping providers. And that gives them a slightly broader range of qualified activities. Their advocacy activities are qualified pretty much if they can make an argument that it assists advocates who provide civil legal services to indigent persons without charge. That's a low bar, but it's not a non-existent bar. So we do check to make sure that things fit under it. Those are the standards that we use for consideration. Oh gosh, I'm sorry, I didn't fill in these 2 blanks. And now that I'm sitting here, I can't remember the dates. Erica, do you happen to remember when the ILAW reports were due? I think it was the end of February.
They were released, I believe, at the end of January, and they were due March 11th.
That sounds right. Thank you. March 11th, the ILAW reports came in. Every grantee had to submit at least a main report, and then they submitted individual activity reports if they had individual activities to report, up to 25 of them. So we had 104 grantees, 104 main reports, and then 900 individual activity reports. So just a little over 1,000 reports altogether that staff have reviewed to make this report today. Of these, thankfully, 777 were clearly qualified based on those criteria we discussed. 35 of them were identified as non-qualified by the grantee, so that was easy. And then there were another 88 that we wanted to bring to your attention. They fall into 4 groups, most of which staff have made tentative recommendations on already. And those are with respect to fines, fees, and convictions, work that's previously been recognized as having a significant impact on indigent people. Reports have demonstrated a disproportionate or particular impact on indigent people. And then for your delectation, reports elevated for your review. I believe that that last section is the smallest of all. So I think that we set this up right. It's a little wordy, but let me see if I can cut to the chase. Last year, a question arose with regard to fines, fees, and convictions, and work related to those. And the conclusion of State Bar's Office of General Counsel was that that work was not qualified for funding with IOLTA grants, and that the commission had latitude to determine whether it wanted to find them eligible or qualified during the eligibility process. And the commission determined that it wanted to find them eligible during the qualified during the eligibility process, and to undertake some legislative advocacy to have that rule change, that statute change. And advocacy was successful. The rule has been changed, but not retroactively. So going forward, this issue isn't going to be an issue, but for the last time, we need to get the commission's approval of a finding that activities were qualified when they concerned fines, fees, and expungements. There were 2 impact litigations, 1 advocacy activity. We bring these to you individually, sort of as a historical convention. I don't know if we need to have a different recommendation or approval for each of these, and I would turn to Brady, Erica, or Dwan for that. But looking at them individually, these cases we think should be approved. Let me pause here and just make sure we don't need a motion and to answer any questions that came up.
So can I just ask, are we gonna do these one by one? Like, would it be easier to do motions as we go, or do you want to do them all and then at the end? What would be easiest for, what do you anticipate?
Well, in the end, there's only 4 that there's really a question about in staff's mind. So to the extent that the committee is willing to confirm staff's tentative recommendation of approval, I'd suggest that we could just bundle those. As
Great.
for any that would,
Brady?
I mean, I would think that the recommendation could be, because even on the questionable ones, there is a recommendation. So we could go through these and until there's one where it seems like there might be a going different than the staff recommendation. Ultimately, there could be one motion to approve all staff recommendations.
Got it. Okay, that works.
sweet.
But why don't we take a quick poll? Does anybody have any questions or concerns about this particular recommendation? Okay, I don't see any hands raised. So Dan, feel free to continue on.
Excellent. This is another sort of discussion area that may be familiar to veterans on this committee. Starting in 2019, there have been a few categories of legal work that have been regularly recognized as having such a major impact on indigent people that even when the ILAW reports didn't provide clear evidence that a majority of those impacted were indigent, or that the plaintiff was indigent, or something else that really fit within those clear criteria we described before. In these areas, the impact was self-evident. And again, beginning in 2019, and then we got like 4 of them in 2019 and added 2 in 2020. These have been areas where the committee has been amenable to staff's recommendation of approval, even though the specific data in the report wasn't of like scientific clarity. And just to be clear, if there was evidence that was really clear, they didn't appear on this. There's lots of work in all of these areas where the evidence was very clear, and we're not asking for your consideration on this. But here, it's we call them the buckets. And every year we've been asking for approval for cases in the buckets for those reasons. Hi, Pamela, what's up?
Hey, my question is that there's just like a blanket just for advocacy through litigation to advocacy. Will this decision depend on the location of those individuals? So if these individuals are on the maps that are listed in our materials in terms of Northern and Southern California, that's an easy yes. But what if it's not?
Well, all of these activities are within California.
Okay.
And each of them has made a pretty persuasive argument from staff's perspective that if not the majority of people impacted are going to be indigent, that the primary impact will be on indigent people in California, or that the indigent people will be the ones who have the most significant impact. So those were bases for us to say it looks good to us, and we wanted to know if any further information would be necessary before those determinations could be confirmed.
Catherine?
If you're asking now for a response, I agree with your analysis. And I've often looked at the data about who's impacted by each of those because my former organization did that work. So I feel confident that that's the correct call.
Thank you. There's one other much like this, and these were reports that sort of sorted themselves in some categories, but I don't want to get caught up in those boldface identities. In each of these instances, each of these reports provided persuasive data or argumentation that indigent people would be disproportionately affected or impacted. They don't come within those other buckets. We didn't have a special category for them, but in each of these cases, we could see that a strong case had been made and staff found disproportionate impact, but wanted to bring those determinations to the committee because it's a judgment call, and we wanted to know if any further information would be needed or if there were questions about them.
Hold on.
Right.
There.
Judge Klein?
It's not worth it with a.
Okay, I'm gonna,
Did you unmute yourself?
Yeah, no, it's the speaker.
Hold on. Sorry.
Boy, it better be a good question. I didn't realize we did criminal. Isn't bail bonds criminal?
Well, actually, these are bail bond contracts. So there's a.
Oh, you can't hear me?
No, I can't hear the answer. Can you hear the answer?
Oh, no, because you're, hold on. You want, just, why don't we just work your speaker, not mine?
Okay.
All right.
Yep. Is your speaker off?
Yeah.
We good?
I turned it off.
Okay.
Well,
Good. I'm going to turn off.
maybe not.
Two people.
This is not working.
one room
If
is.
one person mutes and turns off their speaker, the other one should be okay.
Well, it's a quick question. Bail bonds, isn't that criminal?
Bail bonds are, but these, I use shorthand, but it's actually bail bond contracts. These are lawsuits against a company that has bail bonds and contracts of adhesion.
So is this more of a consumer issue? So people who get bail bonds and then for whatever reason, something screwy goes and is that the kind of nature, not related to the reason they're getting bail?
It's unrelated to the offense. It has only to do with the terms of the contract.
Yeah, right.
They're like payday loans, you know, they're extortionate and people can't get out from under them. So I wasn't aware of it. And I think that this is a good place just to mention that our grantees do some spectacular work. You just don't get the sense of it from any of what we can present here. And for most of what they give us, because our questions are so specific, but boy, these people really get into the weeds. They get way into the stratosphere, everywhere in between. It's just inspirational. Hi, Catherine. What's your question?
I have to unmute too. So on the question of identity theft, what data was there that showed, I mean, identity theft to me seems like a rampant problem. I get notices all the time that some company didn't secure its data and therefore, you know, so I guess what's the data that shows identity theft is disproportionate to low income people?
Well, they were showing that their services were specific to providing resources for low-income people to deal with these issues, many of whom don't learn about it and don't find out about it until it's much too late. And because of the kind of transactions a lot of low-income people get involved in, they're more susceptible to having data stolen, to having information disappear. So not only are they disproportionately represented among victims of identity theft based on this information, but the impact on them is worse because they have less cushion and less capacity to deal with it. Hi, Pamela.
Did you already indicate what fiscal year these activities were for or not?
I didn't. These are all
Okay.
activities that took place during calendar year 2021.
Okay.
So I'm sorry, what was the advocacy activity then related to identity theft? So these are advocacy, these are reports, and it says 7 advocacy activities. You listed the topics. So what advocacy was undertaken, and was this legislative advocacy or
because you sort of describe it as sort of like direct representation, and direct representation, that's easy because your clients are indigent people, right? So that's easy and doesn't, that seems very different to me than a broader advocacy where you're trying to make the disproportionality argument.
That question, I don't have an answer on the tip of my tongue. I actually reviewed that one myself. We had 7 different teams, but that one was in my portfolio, and I can't remember exactly what they presented, but I can get back to you with that, you know, during this meeting if we end on time. And I think that this is my last slide that I present. After this, I turn it over to Erica, so I can get that information for you shortly. But
I'm going to ask a question on Catherine's to avoid the problem. I didn't realize hate crimes are disproportionately the victims of disproportionately poor people.
The evidence presented indicated that these were activities that were concentrated in economically depressed areas, focusing on people who were historically excluded from jobs and opportunities, who are generally of, in these communities, there are a lot of low income people. And there were some actually really hard questions that came up with respect to this. So I'd be happy to provide some more information if you'd like.
It sounds to me like you're talking more about discrimination than actual, perpetration of violence against hate crimes. I mean, obviously gays are victims. They're the victims in areas that are not particularly poor, like West Hollywood. And that's why I'm surprised that would be disproportionately against poor people. Now, you seem to be describing more issues of discrimination. Is that really what we're talking about, rather than someone beating up someone considered gay or Asian or Jewish?
I think also maybe Dan, to address Judge Klein's point, is what was the advocacy effort? So was it to pass new legislation, or like what was done to address?
Yeah, if I can jump in, my recollection of that activity was that it was the title of it was an equity budget. It had to do with hate crimes against Asian American Pacific Islanders. And the organization had presented information that, and this is something that has come up in the Rules Committee about what type of data or evidence the organization can provide, that one thing under consideration was their own internal data. And so they had received many calls, and I forget what the percentage was. I think it was about 75% of the calls related to hate crimes that people had experienced were from indigent persons or older adults, which also qualify as indigent. And so they had presented that data from their own experience of working with individuals who had experienced hate crimes within that community, that they were primarily indigent. They also had the explanation that it has a disproportionate, what they were seeking through this legislative action was to increase resources for victims of hate crimes. And they explained that individuals who are low income have less access to resources. For, I think the example they gave was, if you need mental health resources, if you are not indigent, you might be able to pay for that through insurance, or you might just be able to pay out of pocket. But individuals who would benefit from this equity budget might not have any other resources available to them. And so they would be disproportionately benefiting from the passage of that budget. So I think those were the main points in support of their activity.
Seems to me what they're really talking about is victims of violent crime in general. I don't know, who are generally poor people.
Well, I think this category of disproportionate impact, that is the point, that it's not confined to solely or even majority impacting indigent persons. It's that indigent persons would have a significant benefit as compared to the rest of the community. So it is, yes, you are correct that it would have an impact on anybody who's experienced a hate crime, but that was not the focus of their activity, or that was not the motivation behind them undertaking it.
I mean, the other problem is there's a lot of disagreement with some of the classification you're taking place with a lot of crime like San Francisco or parts of LA, and if an Asian's the victim, is it a hate crime, or they just, you understand my point? It seems like a very rough classification as to what's a hate crime and what isn't. People get robbed all the time. Anyway,
So
it's a bit of a stretch, but I guess I haven't seen the data.
did they present, so just to clarify, and maybe Dan mentioned this, but I just wanted to make sure we had the point that in the past, we've generally, sort of looked at this in sort of two ways. One was at a numbers level, does it disproportionately affect like a majority, our indigent people? And then the other side of it is, even if it's not a majority, would people who are indigent get more benefit than people who are not? And, I think the issue of your point, Judge Klein, about whether it's a hate crime or not, I'm not sure if that's a criteria. Is that a criteria for the advocacy work that they did?
Well, that feels a little bit like it's a question of the application, but this would be legislative advocacy to create a resource. I recognize that it's not easy to decide who gets something out of the public benefit, but establishing that benefit itself wouldn't be specific to any activity.
Yeah. Can I had raised my hand. Sorry, Catherine. I'm just going to ask my question really quick and then I'll get yours. Mine is actually about the Judicial Council pleadings forms. And I'm curious as to what kind of revisions were advocated for. Are these for self-represented people or just, the reason I'm curious is like, I use Judicial Council forms all the time. So I'm kind of curious and why they were beneficial to indigent people in particular. Are they clear to understand for a layperson? So that's my question.
Dan, I don't know if you recall, I think this was for small claims forms.
I think it was. And I do recall that it was to simplify and clarify forms that were specifically relied upon heavily by self-represented litigants and often by those who are very low on resources. So it's one of those progressive benefits. The less you've got, the more helpful it is.
Okay, thank you. Catherine?
I think my comment was just a bit more general, and I feel like these are all really good discussions. It just might help to have a little more summary information going forward on this recommendation. So I'm fine with the prior.
Right.
Because I think we all understand how, housing or education where, the majority of school children are poor in public school, et cetera. But it just feels like for these, like each of us are pulling out one that doesn't seem intuitive to us, and there really isn't any information, because this is an individual determination, not a we think this group. And so I find it hard to know what the right decision is without that information, like, because it comes across as we think all judicial pleading forms should be just on the face of it accepted. And I agree with Erica, like if they primarily relate to low income people, then yes, that makes sense. But we don't have that here. I think that's why you're getting so many questions.
Just to reflect that back, I'm hearing that it would be, the committee would be more comfortable, proceeding with this matter, these items, with more information. And we can certainly pull together a little summary or give you the reports, figure out a way to package this information so that you can see the basis for staff's determination and see whether there's a question about it. Hi, Pamela, you have a question?
Yes, one for the Judicial Council forms. Does not that organization already manage that department, so to speak? And for the fiscal year, we're talking about 2021, when there were, again, we were asked to be flexible. There was still a lot of people that were via Zoom managing things and were not out and about as much as we'd like to have been. So what was the agencies or groups workaround of the pandemic restrictions in order to accommodate the work?
Well, that's two questions. So let me do the first one. This activity was actually undertaken by one of our grantees that went to conduct advocacy with the Judicial Council. So the council's getting paid to do their own work, but our grantee went in to try to shape that work. That's what that looked like. Oh shoot. How did they adjust to service delivery questions? This is another one of those places where if you read 900 reports, you really see a spectrum of responses, so broad that it's hard to give a specific answer. So I'll just say the organizations were very creative. Things changed over the course of the year, sometimes faster than others in different parts of the state or different legal areas. So there's a really wide range of going into the community, working directly with the courts, doing everything completely remotely. It depends. Erica, I'm thinking that we should put a pin in this one so that we can provide more information.
Can I ask first, what kind of timing is it that staff needs? Because what I don't want to do is, you know, if you guys need an answer to this sooner than later and we need to wait until June, you know, I don't want to, this could be another one where we delegate on these particular issues or ask a working group to kind of vet some of this and get the information. I'm just trying to be creative, but I don't want to impinge on staff on this, but so let me just check in with that.
So this implicates qualified expenditures as part of the 2023 ILTA EAF application. So based on, you know, what's decided today, if something's qualifying, then the organization can include that in their expenditures. If it's found non-qualifying, they should deduct it before they submit the application. That being said, I think as we've referenced throughout the meeting, we often have to go back to organizations and make adjustments during the application review period. So if it's not decided today or is not decided before the application is due, staff would follow up individually with organizations if they do need to make any adjustments later. But from, you know, the grantee's perspective, if they can just get it done from the outset and have it be correct, that would be great, but it is possible to adjust later if necessary.
It's not like the audits.
Okay. Yeah, I think, I don't know. And this, I know you guys included the applications in the memo. And so I don't know, it seems as if maybe, you know, if there's something that you think from the applications that we're missing that might provide more details.
Well, I don't think that the memo includes details on these 15 activities. There are 4 that are specifically up for your consideration, but no,
I understand the memo is a little bit high level, which is fine, but I know you also attached some application materials, and I'm just wondering whether the application materials that are attached to the memo have more details on these particular topics, and if not, no problem, then we can, okay, that's fine. I just didn't know if there's something we should be reviewing on our own. So
there is, but I need to get it to you. So that doesn't exist yet. However, it's easily generated. So, you know, I don't think that this is a matter of such like time sensitivity that you need to take action without having like the information you need.
Okay. So can I, so that it can be more, we can be productive on the next go round, if maybe committee members could give a couple of, you know, what they are looking for in the information so that staff has some like good concrete guidance. And I think I will speak for myself. I think to the extent that you guys, that the memo can just maybe with a sentence or 2 for each one, maybe connect a little bit more concretely to the indigency part, like for example, on the Judicial Council pleadings forms, like if you make the point that it's small claims and they use small claims, hopefully this is stuff you can pull from the organizations. But Dawn, you have your hand raised. Are we asking too much? If we are, please
No,
push back.
I'm saying, do you want to just look at the ILAW report itself? Because there's like some direct questions, because it is more work for us, but that's not the concern. We just don't want to summarize it incorrectly for you. It seems like maybe you want to just go to the direct source material, which is the ILAW report themselves.
I was thinking of just trying to pull that data for these and being able to show them all in a stack.
I think that's actually a really good way to do it, because then you guys, all you have to do is pull it, send it to us, put it on us, we'll review them, obviously through the lens of what staff has recommended, and then we can, I think, hopefully feel assured on the connections. And if there's further questions, then obviously. Okay, thank you, Dawn. That's a great point.
So I've got a to-do on slide 10 here, but I'm going to move on to slide 11 and turn it over to Erica, because we officially didn't have a recommendation as to these matters. And, we were hoping to get some input.
Yeah, I mean, I think we did
blank lines.
Yeah. I think we did tentatively recommend the following activities as non-qualifying, but, acknowledged that this might be area for deeper committee discussion. So the tentative recommendation is to find these non-qualifying, but in your memo, staff raised, as Dan noted, 4 individual activities for consideration by the committee. 3 of them were impact litigation activities from public counsel. The reason that they raised concern was that they were conducted outside of California, and under our eligibility guidelines, work on behalf of indigent persons should be performed in California. They also had 3 other activities that were outside of the state, but they had indicated that it was binding on indigent Californians, like it was in the 9th Circuit, for example. So the 3 that were raised were 1 state case from New York, and then I believe 2 federal cases that were outside of the 9th Circuit. The organization indicated that they felt that the work was qualifying because it could provide persuasive authority in deciding cases with similar issues in California, or model guidance on issues. I think one of them related to foster care, and public counsel noted that, that there are often nationwide conversations going on about foster care. And so the outcome in one case could provide model guidance in a case that would be similar in California. But staff raised those 3 cases because they are out of state. There is no direct connection to California. It's not binding precedent in California as far as we understand it. And so that's why we recommended those 3 activities as non-qualifying. But it looks like somebody from public counsel has raised their hand if we can let him chime in about that.
Is this like an answer to a question?
This is Mark Rosenbaum.
Sure.
I was going to respond about the public counsel cases if this is an appropriate time.
Okay.
First of all, thank you for making time to listen to us. We really appreciate it. And I know what you all do, and I appreciate what you've done for years and years. I want to give you, if I may, just a brief sense of what the thinking is. And I just want to pull off of the 3 cases for a moment to describe that. We do a lot of educational justice work, educational equity work involving low-income children in California. We filed a case, one of the cases that we had discussed with our community partners in California dealt with the large numbers of students in California who were functionally illiterate, who did not meet professional definitions or common sense definitions of literacy. We filed a suit in 2016 in Detroit that sought to achieve for the first time a constitutional right of access to literacy on behalf of children in Detroit. We selected Detroit because Detroit had the lowest literacy proficiency rate of any school district in the United States. We actually had many community partners here in California put us in contact with partners they worked with in the Detroit area. We litigated the case successfully and obtained a positive decision in the Sixth Circuit Court of Appeals, which then became the basis for filing a suit in California that achieved we filed a case seeking under the California Constitution a determination that that Constitution established a constitutional right of access to literacy. It was a statewide case. 11 out of the 26 lowest performing districts of the 200 largest districts in the United States were in California. We spent substantial time working with groups and individuals, all of whom are indigent kids. We used the Detroit case as our template, both in terms of designing the case, working with community partners, developing the legal theory, and ultimately as persuasive authority. Yesterday, I was part of a statewide EdSource sponsored roundtable to discuss the settlement in that case, which brought $75 million to $53 million to the 75 lowest performing schools in California, and nails down in California statute a right of access to literacy, and in fact a model for developing strategic plans and implementation of those plans to assist those kids. And the purpose of this roundtable yesterday was to describe statewide, I think we had over 1,000 participants, the successes and the ways that those districts and the state of California have gone about implementing the objective of the lawsuit. That's the model. The three cases that we've come to you on follow precisely the same strategic methodology. Occasionally, most of our cases, the overwhelming number of our cases are, of course, in California. But occasionally on very complex, very difficult, very challenging legal issues, we may look for a set of facts that are the most dramatic in terms of building this legal theory, developing partnerships, and developing a team of experts to work on these cases. And that's what those three cases are about. The Integrate NYC case is filed in New York State under the state constitution, as you said, Daniel. It is the New York Constitution with respect to education, the education article of the New York Constitution, pretty good replica of the California Constitution. New York City, which is where the case is centered, is the most segregated school district in the United States of large school districts. The young people there experience racial animosity. They do not see teachers who look anything like them. They see curriculum where they see more books with on their covers animals rather than persons of color. And there are many, many, many tragic examples of racial.
Mr. Rosenbaum, I'm sorry to interrupt you, but we generally try to keep public comment to about 3 minutes. And so I want to let it open up to let committee members ask you any questions about it, since we have you and you're such a great resource. And one thing I would like to start a quick question, which is, to the extent that these model litigations in other jurisdictions are unsuccessful, then what happens?
They're always successful.
Well, you know that there are risks in litigation. I'm asking a hypothetical. If they're not successful, to what extent do they impact California residents?
Well, first of all, I want to say
Yeah.
I hear what you're saying. I just want to say
Yeah.
that we've never had an unsuccessful case. But
Sure, fair. Which
take it-
I appreciate, and I understand you guys are very thoughtful about how you bring your case, but I'm just asking, you know.
I don't think does it rule out any bringing litigation? No, I wouldn't see that. In fact, I'd say we'd learn from whatever experience we had in a jurisdiction where it was in fact unsuccessful. You know, we'd still build the same model, we'd still have the same experts, we'd still use the same fact situations, and we would adjust them if they were unsuccessful to address what the deficiencies were in the litigation itself.
Okay. Let me see if other members of the committee have questions they'd like to ask you since we have you.
You know, I apologize. Yeah, I didn't know about the time limit, and I'm sorry. I
Oh,
know.
no, that's okay. We usually do public comment at the very beginning, and I'd sort of given my caution then. And so I should have warned you at the outset, but I do appreciate the information you provided. So Catherine, you have your hand raised?
So this is, I have a question, but Judge Klein wanted to go first, and we're now sharing a computer, so.
Okay.
I don't have to go
Fine.
first. We're trying to, I have two questions. Maybe it's not fair. One, is there a way to separate the costs of the California litigation versus the litigation in New York and Michigan? And second, I think rather obvious question, there aren't lawyers in New York that could handle that case with some coordinating with you, and then you handle the California aspect. It seems strange that you would have to actually file in New York, considering there are a lot of good public advocacy and public interest law firms in New York, I assume in Detroit.
There are obviously outstanding lawyers in all these communities. I think we are regarded as experts in these areas. I frequently do consult. I was on a call this morning consulting with regarding a case in Boston. But I mean, we are regarded as experts in each of these areas. Each of these are novel theories that have not been developed elsewhere. So I think, Judge, that's the best answer I can give you. I can tell you that there were not lawyers there bringing cases remotely like these sorts of cases. In terms of the finances, help me understand exactly what you mean by that, please.
Well, you mentioned the importance of the New York and Detroit cases were their application in California.
Right.
So in looking at, you know, if you were billing like a private law firm, and I was never in private practice, so forgive my ignorance, couldn't you make the argument, couldn't you separate that you should be entitled to funds for these cases in the litigation in California rather than the whole package involving New York? I don't know how I phrase that.
No, that's a good question. And I haven't given that thought before. I think it would be difficult because it's the whole package with respect to the litigation that then gets imported into the California litigation and advocacy. I don't regard there as, you know, superfluous pieces of it. It all comes in lock, stock, and barrel. But I want to be honest with you, Your Honor, that I just have never given serious thought as to how that could actually be.
I don't know where the word superfluous came in. I didn't mean to suggest it was superfluous. And I thought you brought a case on the Compton School District, but anyway, I could be wrong.
I did, and that's a great point, because the Compton School District case, which was a trauma case, actually led to the Kevin S. case, which is the first case in the country that uses trauma as a basis for describing what happens to young people who are in the foster care system. It was a first trauma-focused case, totally based on what we had achieved in Compton. And now that is going to come back with respect to addressing the foster care system here in California. I mean, I have certain attorney-client concerns in terms of how much I can say about that, but Kevin S., New Mexico was the worst, by any standard, the worst foster care system in the country. We got a smashing victory there that led to legislation, and now having developed that trauma theory, we're bringing it back to California.
So I want to ask a somewhat different but related question. And so to me, this is like the work you do, I know personally and professionally, is outstanding. So the question before this committee is, what is the line between what the statute allows us to count as expenditures because of a direct impact on Californians, right? And I think I worry a little that if the committee adopted your approach, which is we bring a case in another state and we're ultimately, if we're successful, which you say you always are, going to bring a case in California. Certainly your California work is allowed, but should every case that another organization, not even public counsel, brings in another state be allowed as eligible for funding with the resources that California has available to distribute to programs in California? So I think that's really what we're wrestling with, because your very broad view of how this could apply, I think we would be making a decision not just on these cases, but really a decision about litigation that's brought that ultimately can influence California. So kind of a question and a statement, but I honestly think that's what the committee's wrestling with, not the value of the work or any of those, just what does the statute allow us to count in terms of, in the current year, impact on California? It's not like future impact, but current year impact.
I understand that. And it's very nice to see you, Kathy. Here's how I would answer that question. I mean, these are such tough issues and such tough problems that we have to find a way to make it work for kids here in California, because California has the largest group of kids for any problem that we want to talk about. The Scott C case was a homeless case. 19% of all homeless kids, students, are here in California, in the United States. I would suggest as a test is whether there is a proximate relationship between the work that is being done outside the state of California and an impact with respect to, first, whether or not an identical or substantially similar problem exists in California, and second, whether or not there are efforts, good faith efforts being made to take the product of the out-of-state case and bring it for the benefit of, in this case, the young people in the state of California. But I think the danger is going the other way. And that is to say that setting a categorical rule that because the litigation itself is in another state, it can have no relevance to the children or the clients in California. That, I think, would be a violation of both the letter and the spirit of the statute. And I think it would hurt low-income persons in California, because the objective is to find ways to win and find ways to benefit. And this seems to me to be a good faith and successful track record way of doing that. A categorical bar would hurt low-income persons in California.
Thank you. Brady, you had your hand raised, and I am kind of curious as to your view on what latitude we even have on this issue.
Yeah, so I'd originally, and I think Catherine nailed it, I think there was a little bit of cross purposes between Judge Klein's question, in that I think maybe Justice Klein was understanding some of this work that we're questioning whether to fund or not actually being in California, and that's not my understanding. It's, if this leads to a California case, that's certainly fundable. I'm very supportive of this work, obviously, but I think it's just too attenuated. The statute is for work in California. It's a stretch with the Ninth Circuit, but again, that's binding, and that's going to have an immediate impact. And here, yes, you can tell a qualitative story that one litigation in New York is going to be more integral than others. But I think Catherine's question really nailed it, and there has to be some line. So I would be very uncomfortable with funding out-of-state litigation that's not binding here.
There,
Can I ask a question, Mr. Rosenbaum?
Sure.
I guess if there's a national injunction, it could
I
be
agree.
binding.
I agree with that. If it's a national class, which seems hard, but if you had a national class action,
Yeah,
that California residents were part of it, absolutely, that's would fall within it, I think.
yeah.
What
Okay.
if it, can I ask you a question? So if I call an expert in New York City about a case I have in California, I can bill for that, and that from what I've just heard and what I understand, that comfortably fits. In the cases that we're talking about today, it could be parsed as to work that was done in terms of expert relationships, developing legal theories that fit exactly with respect to work in California. So I guess what I'm saying is, if you want to create dividing lines, there are some dividing lines that I could imagine developing or recognizing as to how to parse that out. I don't think that would be terribly hard to do. And as I said, I've said it, I think a categorical rule is not going to help. It's going to backfire in terms of low-income persons here in California.
Mr. Rosenbaum, I'm kind of curious as to what you're envisioning. So are you saying that if you use an expert, if you have parallel litigation and in some ways some work that you do, like let's say you have a case in California and a case in New York, and the work in the New York case, also serves the purpose of the California case that's already initiated? Is that what you're envisioning? Or are you envisioning?
Or that it germinates into the California work.
I'm a little, this is just my view. I'm a little uncomfortable with the germinates because it seems as if that is a hypothetical case that isn't actually brought yet. And so what I think for me, part of the concern is you said your standard is, well, a good faith basis to bring it back to California. But like, what if you ultimately decide like, oh, this isn't going to work in California, but we've now funded New York work. So I think that's why, and I think that's consistent with our obligations under the statute, that it has to be work in California. That's a little bit of my concern as well on this, how this is going to impact. But that's just my point.
But it would seem, so an example of what feels comfortable to me for sure is you're doing a case in New York. You haven't brought a case in California yet, but you're developing a case in California with California clients. And you're using the same expert that you're using in New York to help you, assess what's going on in California. The time that the New York expert spends working on the preliminary work you're doing in California. You don't have to bring everything to a case. That takes time for all of us. But you have California clients. That work seems like it would be covered in California as an advocacy pre-litigation kind of strategy, right? Because there's a direct California connection. And I see, I'll be quiet because I see Brady has his hand up.
I agree. I mean, you can apportion your expenses to a California matter. That's not what this appeared to be.
I understand what you're saying. I appreciate what you're saying.
So do you have, is there pre-litigation? Do you have sort of California, or is this purely an out-of-state case?
Let me see if I understand your question correctly. One of the criteria that we have before we file an out-of-state case is this case going to have benefit in California itself? So we don't do a case without first determining that a similar or identical issue exists in California, and it's something that we're going to do. I gave the literacy example as an exemplar of that. Does that answer your question? I'm not sure that I'm answering your question fairly.
And I think we're just going a little further to ask whether there are actual clients in California you're currently working with.
Absolutely.
Right?
For all three of the
Are-
cases, all three of the
But then I
cases.
think it's how do you apportion it for the clients that you have in California that you're currently working with on the identical issue? What is the time, expert, et cetera, that connects to those California children to make that's I think what I hear people on this call saying. And I don't know that I expect you to answer that today. I mean, if there is a way to look at some apportionment of that because you actually have a California group of clients, then I think that's what the committee's asking about. And Dwan has her hand up, so.
Yeah, I was going to say, yeah, if there's a way to tie those expenditures back directly, Mark, or to itemize it. I think from the past staff's perspective, we would recommend to the committee that would be qualifying.
Thank you.
Thanks, Dwan. Yeah, so I think, to the extent that you're able to, look back at the expenses and kind of draw a closer line between the work you're doing in California and the work in these cases, I think we would be more comfortable. But I think just the full litigation out of state, it's just, I think, beyond what we can permissibly approve.
Okay, I appreciate that. Thank
Yeah,
you.
Mark, maybe we could talk offline, and like, if you give us some thoughts, the staff can work with you before we present it to the committee.
I would love that. And this has been a very helpful conversation. Thank you.
Yeah. And I should say, I think everyone sort of said this, but I'll make it a note again. We very much value the work you're doing. None of this is about like the work, the impact that you're doing. And we want to fund, it's just our mandate is, it has to have a close California tie. So.
I know who you all are. You're great.
Yeah.
So,
Okay. I just want to make sure we reiterate that for you because we do
Okay.
that. Yeah. Brady, you had your hand?
No, and I was just going to say, and this also goes without saying, but it's not as if we're keeping this money and not giving it out. This is a pool of money that's going in California. So it's a question of.
I was impressed by the luxury of your setting. So I was wondering where that money was coming from.
Yes. Yeah, that's a very good point. It doesn't improve my volunteer salary or anything because it will go out to another organization. Thank you very much, Mr. Eisenbaum.
Thank you for making time for us.
Yeah. Okay. So this one might be another one we table with if staff thinks that's the right approach until there can be some work and to the extent that anyone on the committee can help with that too, please let us know. We don't mean to keep making more work for staff. Sorry.
Yeah, maybe for this one, if is a volunteer, because I think what we'll do is before your next committee meeting is work with Mark to see what he has and give him some feedback. But if there's another commissioner that would like to help us, I think that might be helpful.
Yeah. Does anyone want to volunteer? Well, I know you're all just super excited. And so if you decide you want to volunteer offline, please feel free. And, if for some reason people are busy, Dwan, you can always ask me and I'm happy to provide.
I'm going to say the same thing. I feel like I volunteer often. So
Yeah.
I want to give other people a chance to participate. But if you need someone like either Erica, it seems like either Erica or I are happy to help. I don't think you need both. So you'll just let us know when you need help.
Yeah, and I'm going to be out of town a fair amount in the next month too, so that's nice.
And Louise, you have your hand raised?
Well, I would volunteer, but I feel like it's a little bit outside of my area of expertise, so I'm not sure how much help I would be. But I would volunteer if you think I could have some kind of input that was worth my time and your time.
Thank you.
Thank you very much. Yeah, just let us know. Okay, next one.
So the last activity that staff had raised individually was the redistricting advocacy by Asian Americans Advancing Justice Los Angeles, which was the activity that Mr. Evans spoke to during public comment earlier. So just very generally, what the activity had to do with was redistricting at the local level. So in cities within the county of Los Angeles, I believe, and other other counties of Southern California. According to the report, the organization was primarily focused on the Asian American Pacific Islander community, as well as the Arab, Middle Eastern, Muslim, and South Asian communities. And they were advocating specifically to keep those communities intact as part of the redistricting process at the local level. You know, they engaged in attending local board meetings, giving feedback on line drawing. They organized in the community. And we're just generally working on sort of enforcement of a new law that went into effect last year. Last year, this committee found redistricting advocacy to be non-qualifying. And so that was one of the reasons that staff raised this activity this year, because last year's activity was at the state level. It was just with the passage of that bill. This was now with the implementation and enforcement of the bill at a local level. But given that that activity was previously found non-qualifying, staff felt that this would be in a similar vein and potentially non-qualifying. Based on the data that Asian Americans Advancing Justice provided in their report, they indicated that there was a significant proportion of indigent persons in these communities that they were representing, but it didn't show that it was primarily indigent, and staff didn't necessarily feel that the report showed that it was disproportionately impacting indigent persons either. So that's why we raised it for discussion with the whole committee, but we are preliminarily recommending it as non-qualifying.
Brady. Or no.
Well, would you like to hear from me now, or have some discussion first?
I have a question maybe before the discussion, and because I'm not remembering this. Is there a question of whether it's legal services as well, or is just the indigency piece?
No, just the indigency piece.
Okay. Okay, Brady, why don't we always value your interpretation, so it might be helpful for guiding our discussion.
So I have, on this one, probably would have the strongest concerns if we were to fund this of anything we've discussed.
Okay.
You know, because yes, they've shown that in the neighborhood that they're looking at, that it's 22.29% versus a 16% indigence in LA County at large. But again, that's not showing certainly anywhere close to a primary impact on the indigent. You know, I welcome Mr. Evans's comments, and they're doing fantastic work. But you know, stakes are higher for indigent persons on any public policy, and here really they're doing great work, and there are many public policy reasons for why to avoid diluting the political power of an ethnic group. But I think that if we were to fund this, I think we'd be running a pretty serious risk of a Prop 209 violation, because we're really making a decision based on the ethnicity of the clients, not the fact that they're indigent. So those are my initial thoughts.
Okay, thank you.
Judge Klein has a comment.
My concern about you getting into policies redistricting is there are other poor communities that might be heavily Latino that could be affected in a negative way if the lines are redrawn. Seems like it's really a mixed question is the issue on the issue of indigency, because we all know that when they're drawing lines, they do look at constituencies and is there a Latino district, etc. 209 notwithstanding, we just don't know where that would be going, what they'd be challenging.
Yeah, I'm assuming there's nothing that says they're trying to redistrict to keep indigent people as a voting bloc. Is that correct? Such that their political voice is stronger regardless of ethnicity?
Correct. Yeah.
Yeah. And Mr. Evans is no longer on the line, I assume. He had a call at 11:30.
No, it doesn't look like he's present anymore.
Okay. Also, and this may not be relevant, but I was thinking about this, but like, is redistricting, I thought it was kind of through an independent commission. I'm sure there's still a lot of lobbying involved, but like,
I think this is
that-
city council.
oh, this is city council? Okay, okay. So, okay, different. That's what I wasn't sure about. Not that it really matters, because I know that there's a fair amount of advocacy there, but I was curious. Any other comments?
I think I'm not that was my recollection. Was that Erica?
Yes, I believe it was with city council or other local election boards. Yeah. It was all at the local level. So individual cities they were advocating with.
Okay, thanks, Erica. Pamela, do you have a?
Yeah, I will ask 3 questions. Just in general, in their materials, they're indicated voter fraud in California. So if they could just share any recent incidents of that. And on page 404, hour 84 of our materials, right above 14, the question or the comment starts with, we engaged within California citizen redistricting. If they could explain that better. And also the next underneath it, we delineated and submitted boundaries for over 63 Asian Pacific individuals and so on. If they could expand on that. And again, in light of the pandemic and how we were, I'll use the word sequestered, but everyone was not able to be out in the public as we would like to have been. So how were they able to accomplish that in terms of soliciting input?
Unfortunately, I don't think we have Mr. Evans. So I don't know if staff is able to address any of the questions, but it's important. I think it's key for you to like include those questions so that we know kind of what some of the concerns were.
Yeah, I think as to the question about voter fraud, I'm not sure where, do you know what page number that's on? Pamela?
Okay, I can probably find it. They list, let me find that again, and I will get that to you.
Okay.
I will get that to you.
But as far as answering your question about the 63 AAPI and AMEMSA communities, they were referring to what are defined as communities of interest. So those were the communities they were representing in their advocacy. So maintaining communities of Asian American, Pacific Islanders, and or Arab, Middle Eastern, Muslim, and South Asian communities intact so that they would have a unified and more influential voice and thereby avoid diluting sort of their voting power or their ability to influence government. So that's what it's referring to, is those specific communities that they were focused on at a local level. So they worked in various cities, so that's why there's multiple communities of interest. I also wanted to kind of revise what I said before. They were working at the local level. This was statewide advocacy, but they had partner organizations in other parts of the state that were doing this work. So it wasn't at the state level, but it did happen throughout the state at the local level.
Right. So it seems as if right now the argument is it benefited these particular ethnic communities. Those ethnic communities tend to have a higher proportion of indigenous individuals. Ergo, it benefited indigenous individuals. And Brady, you're saying there's sort of some concerns about how closely these things are linked. And
well, yeah, and that it's 22% versus 16%. Where they're not, it's not, you know, that more than half of them are indigenous.
I mean, I found that to be what Brady said, the kind of a linchpin of like, if the purpose is to represent indigenous people and their data shows it's these much smaller numbers, it seems very hard to reach that threshold.
I mean, I think we could, you could make the same arguments they're making, that redistricting to benefit Democrats would, because he's talking about the policies and
Right.
and I don't think we'd have any doubt that that's not something we're able to do.
Right. Sure. Okay. Do we have other comments, questions on this one? Doesn't look like it. Okay. So Erica, is that our last one?
Yes.
Okay. So if I have summaries, and committee members, correct me if I'm wrong, our inclination is to approve the first one that Dan talked to us about.
Well, perhaps we could summarize just by saying there were 777 about which staff had no question.
Sure.
There were a handful with regard to convictions, fines, and fees, and there were 6 previously approved categories.
Yep.
And with respect to all of those, my understanding is that the committee concurred in staff's tentative approval.
Yep,
With
that's my
respect to the 15, I believe it's 15, that were identified as disproportionate impact matters. I've agreed to pull the data, not agreed, I'm happy to pull the data and present it so that a more reasoned determination can be made. But those are pending for the time being. And then Erica, I'll turn to you for where we stand on the last ones.
I don't think we needed the data. I think you were just going to pull for us what the applicant said.
Right. Well, you know, that's what I mean.
Oh, okay. Sorry. You don't need to do independent research.
Oh, no, I'm sorry. I just need to go into Smart Simple and pull those responses. So
no problem. I was worried you thought you had to go and I was like, you don't have to do that. We'll just read what they said. Okay, sorry.
Thank you for clarifying. I don't intend to do that much work.
Perfect. And then we have the public counsel one, right, Erica? And that one, I think we were going to hold to sort of see, and then Catherine and I both said, if you need someone, and Louise also said, if you need someone to talk with them on how to maybe parse more finely their expenses. And then the last one is the advancing Asian American justice and or Asian Americans advancing justice. Sorry, I get all the A's confused. I apologize. And that one, I think we're also inclined to adopt staff's recommendation not to approve. Anybody? I mean, not obviously everyone can vote the way they think, but is there a strong consensus or is there a strong sense that I've got any of that wrong on where the committee is falling? Hearing nothing, it seems as if we ought to just do a motion to approve staff recommendations for fines and convictions. The ones we've traditionally found have an indigent impact, and not to approve the other one.
Do you want me to put it up on the PowerPoint?
Yeah, that'd be great.
Helpful.
Let me no, I don't have recommendations specific to those because I wasn't sure how this was going to break down.
I wrote it out quickly.
Thank you. Let me stop sharing that so that I can give it over to you.
Okay. By the way, thank you, staff, so much for all the work. I know that these ILAW reports, they are like a ton of work. And so I know I value very much all the work you guys do to digest 700 or 800 or 900 different reports for us. Thank you.
Sure.
Okay.
So I think this last bullet point in the top portion would need to be removed because we're going to be looking more at those disproportionate impact. That was the one piece I wasn't clear. Okay, so let me take that out.
I think that's correct.
Oh, and also those as to which staff had tentatively recommended approval with no questions or special considerations.
Oh,
okay, yes.
That's like most of them.
So do we need a motion for that? Is that what you're asking for at this point? To approve this
Yes, emotion, as long as that's correctly.
Yep, so
reflects.
I understand I understand it, and I believe it accurately reflects the work that we're gonna approve or deny. So I will recommend approval of the motion for the ILAW reports as reflected on the PowerPoint slide.
Anybody up for seconding?
Maybe Louise. She was raising her hand.
Oh, I didn't see her.
Sorry, Louise, second.
I was muted and I was trying to like get to.
No problem. Okay. Connolly,
Yes.
Cloggy, Fightmaster,
Yes,
Bennett,
Yes.
Blakemore. Blakemore.
Forgot to unmute, yes.
No worries. Thank you. Klein,
Yes.
Meeker,
Yes.
the motion passes. So,
Thank you all.
Thank you. Now, as to the ones that we have sort of not addressed at this meeting, what timing, what do you need from us on getting those prepared? And do we need to approve them in June? Or do you need something before then?
I think June would be fine.
Okay.
Yeah.
And I'll want to get you materials in advance so that you can take a look at them. But you know, at this point, I think that the question has been framed. It's just a question of making sure you have enough information to answer it. So unless there's something that we can do to help you, I don't know what it would be other than giving you the materials you need.
That's fine. I think giving us the materials would be great. The other, unless Brady says it's okay, to the extent that we can get them well before the agenda for June, just so that in my casual reading time, I can go through them.
Yes, it should be no problem to pull this information and get it right out to you.
Yeah, no, I appreciate that on the timing. I just meant if we need, I don't know if we need to like post that you guys sent us this stuff. I don't know how that works, but
Well, this stuff is available to you already on Smart Simple, so I don't know if there's any special need for us to make a unique process.
Yeah,
Okay.
the Bagley-Keene only comes up if you guys are sharing things with each other and creating things.
got it. Perfect. Okay, I just wanted to confirm. Great. And then obviously if something comes up in the interim and you need some volunteers, you know, let us know. Cool. All right. Any other issues, Erica, that we should discuss? Or that you need from us?
I don't think so. It looks like Pam maybe had a.
Oh, yes.
No, I was going to say, I found my questions were from Smart Simple. Actually, we're on, well, page one of 7 of our handout. Spoke to core programs and our question or statement number 3. So I found my questions in here. So.
Oh, okay.
Yeah.
Great. Well, let me just say again, thank you very much, staff. I know this stuff is like a lot of work, and I personally am grateful, and I think I speak on behalf of the committee as far as sharing our gratitude to you for pulling all this stuff together and putting up with our questions for even more details. And so we don't mean to be, you know, if you ever want to push back on us because you think it's, you know, that we can do with less or we can do something different, don't hesitate. But we very, very much value you making our job as easy as you do. And I think unless there's any other comments or questions with that, I'm sure we'll be, you know, those of us who are volunteering, if anyone wants to volunteer, didn't today to work on any of this stuff in the interim, please let Eric know. And yeah, otherwise we'll see each other all in June again.
Great. Thank you.
Thank you all.
Everybody.